Okay, good morning everyone. We're going to go ahead and get started here. Abby is going to go to the back and dim the lights some more and shut the door because the sun's glaring in. So we hope that you'll be able to see the presentation better than last time in the way back. So just let us know if you're still having issues with that. That somehow helped my eyes anyways. I don't know if that helped the screen, but so we're going to go ahead and get started. Again, the packets in the back for the training today, and if you missed the annual client meetings, you can go ahead and get those. We forgot which lights were lit too. So like 1 and 2, Abby, or these ones up here that I think we need to have off to be able to see that. Yeah. That's good. Okay, how about in the back? Do we need the back lights more dimmed if we can figure that out? We'll just go ahead and get started while she figures that out. So what we'll do is we'll first go through your packet that you have in the black folder. This seems to be kind of all right, so I am Cassandra Lusfield. For those of you who don't know me, there's probably a lot of kids and trustees here that have not been here before. So Cassandra Lusfield, owner and sole attorney at the Ford and Lusfield Law Office. Can everyone hear me okay? That sounds bad for me. Now it's good. Okay, I gotta hold it just like this, I think. So, Ford and Lusfield Law Office, and we're still located on the square where we always have been. I took over from Hannon Ford as of January 1st of this year, so Hannon had owned the firm from 2005 until this year where I took it over from him, and I had worked with him for about 1.5 years before I took it over from him. So that's a little bit of my background, and we'll go through the packet next. Okay, so there's going to be a biography of me in there, so you will learn a little bit more about me than what I just said. So also I'm from Elkton, South Dakota, so not from the Windom area, and from Elkton, so not too far away. And I went to USD in Vermillion for law school. And a couple other things on my biography there is a co-author of the medical assistance booklet that Hannon and I wrote that we hand out to medical assistance clients in nursing homes and things. And then I'm a member of the National Academy of Elder Law Attorneys. And then behind the biography, you're going to see the slides for today. Sorry, I might kind of be ready. The slides for today, we have it printed out. And we have it printed out so that way you have the notes on the side, the lines to write any notes that you may need to. And I know that by doing that, it makes the letters a little bit smaller on there. And so this time I'm going to do my best not to cover the screen like I was doing at the last meeting. If you have any questions while we go along, raise your hand, yell them out, however you're comfortable with that. And we can do some questions afterwards, and like always, I will be here to ask questions one-on-one too if you want to come up as people leave and ask questions more privately. On the right side, you're going to find your client suggestion form. So we did these a little different this year, and they look just like the annual client meeting ones. We want to know what we're doing well, what we can do better, any other suggestions and things. And then on the back is another spot to put where whether you think we should change when these meetings are. So at the annual client meeting, we talked a lot about that, about when we should have the annual client meeting and the trustees training, because in November, we get a lot of snowbirds and things. Some people might still be out in the fields. but then we don't know many of the law changes yet that happen, and that's the main reason for the annual client meeting, is to update you on the law changes. So we're tossing around the idea of moving the annual client meeting to the spring before planting season, and seeing if that can help with some things and make sure we know all the law changes at that point. So then usually we have the trustees training about 2 weeks after the annual client meeting. So then we'd also have this meeting in this spring as well. But then we also get feedback about maybe having the trustees training more around the holidays when the kids are home. So leave comments on what you think would work best, because we're trying to figure out a way to make these meetings work best for as much people as we can, and make sure that also too that we know law changes and things. So please provide your feedback on that. And then we have a new website. We're having some issues with getting it rolled out, but it'll get rolled out for sure for you guys to go look at it by the time we need to get these videos posted. So just like the annual client meeting, we're posting the video there within 30 days after that presentation on our YouTube channel. And you have that link that was on your annual client meeting packets. And then I also have that YouTube channel on the very last page of the slides in your presentation as well. So that's where you would go to find our link, or to find where these videos are being posted of these meetings. And then the last thing is the successor trustee manual. That's always in there, so for your light reading. But it really is some good information. So I am going to be giving a general overview of trusts and the trustees and what their duties and role is. But that trustees manual obviously has a lot more details and can lay things out, and you know, once you hear me talk, it may not make a whole lot of sense, and then maybe once you read through that, it'll all kind of circle together. So it's a good manual to have, and if you need more for any more of your trustees or children, just let us know. I think we do have some extra packets in the back too. We can give you some of those, or you can always contact our office and ask for it. We can mail it out, email, fax it, whatever. Okay, so that should be it for the packet. Can everyone still see okay, hear me okay? Okay, she is going to turn these lights down. Okay, much better? Okay. Okay, so like I mentioned, this is the nuts and bolts trustees training. So this is for the trustees, the kids. Most of our clients, their children are the trustees, and so most of the time clients are like, you know, do you ever explain this to our kids? If we try to explain it to our kids, I don't think we're going to really know. It's a lot trying to explain it to them. So we like to have these meetings every year where you can bring them and we can at least get a general overview of what their roles and duties are. And of course, if 1 year in life plan, your trustees, your kids can call and ask me questions if it relates to your estate planning. Obviously, I need to have your consent to talk to them, but know that your life plan would cover them calling, not just you, with questions about your specific estate planning. And then, of course, a lot of clients like to do an in-person review of their trust book with me and their kids, either at their home or in our conference room at our office. So that is something that you can do as well. The downside to that is when you do that and meet in person with me in the office, that's charged hourly then, that your life plan doesn't cover. But some people are just kind of like, you know what, that's okay. It's beneficial to get everyone there, so then that way you can explain it, they can ask questions, and everyone can get on the same page. So you're welcome to do that too, and call and schedule those reviews with your trustees and your kids. Okay, so some general information information, of course, we have to have the lawyer language in here that this is general information, this is not intended as specific legal advice, and you should consult an attorney or, like I said, come to me specifically one-on-one where we can really go into your specific plans and I can give you specific advice for your plans, or this is more of just a general idea of what the trustees need to do. And then, of course, the attorney-client privilege, you all have probably heard me say this before, and like I just said, I need your consent to talk to your kids, so ethically, I'm unable to tell anyone your private legal information, confidential information, unless you give me consent to do that. So it's an important thing too with your children and your trustees that unless I have the consent from you to talk to them, I can't talk to them. So that's something that's important, and most people, I'm okay with you just giving me verbal confirmation that I can do that, or I'll write it in my notes. It doesn't seem to be an issue, but just keep that in mind, especially maybe for the children and trustees if they just want to call me up without talking to mom and dad don't know, and I don't know if mom and dad want me to talk to them and things. So just make sure everyone's on the same page so that I'm not doing anything ethically I shouldn't be doing. Okay, so we like to give a little introduction to the trustees of why did your parents or these trust makers do the trust as their estate planning? Why don't they just have a simple will that says how their assets pass down? And we'll give a little introduction to why doing a trust. So, as many of you have heard me say, most estate plans don't work, and so the reasons that they don't work is, you can decide how you want to do your estate planning, right? So you can go and you could go online to like LegalZoom, print off some documents, fill them in, and I think just by me saying that, there's probably some issues there. Is maybe you don't know, you aren't a lawyer, you don't know the laws or what you're doing there. You maybe can't get all the specifics and details in it with that. Or just going in and doing just a simple will, which again a lot of you know is that's a great way to help avoid probate, but it doesn't provide much more benefits and protections than that. So two, you can decide whether to work with a counseling-oriented attorney with figuring out where are you going to go, how are you going to do your planning. Are you going to go to someone that specializes in estate planning and elder law? And that's something that I usually mention at the beginning. So Hannon, with the Ford Law Office, he specialized just in estate planning and elder law. So now that I've taken over, I'm still just specializing in estate planning and elder law and don't do any other areas of law. So we're really able to focus in and sit down with our clients a couple hours at a time to really hear their goals and the specific things that they want and make it happen in their documents. Another strategy here why most estate plans don't work is you get your will, you get your trust done, but are you keeping it updated, right? So just getting it done, signing it, and moving on, there's changes that happen in your life, in your personal life, your law changes and things that you want to make sure once you get those documents done that you're keeping them updated. At least, every couple years, but for those of you in our life plan program, you're keeping that updated every year. So that's what we recommend is establishing and maintaining that professional updating program, which ours is the life plan, where then we make sure that we're giving you phone calls, no additional charge, answering your questions, making your changes to your documents at no additional charge, and keeping your asset list updated as well at no additional charge. And then at these meetings, the annual client meeting, letting you know here are the law changes and things that have happened this year, that are going to happen the next year. Here's how you might want to change your trust accordingly. So those are just some quick reasons why you want to be a part of a plan that keeps your plans updated. Even if you just have a trust established, you want to make sure that if any personal changes come up, typically it's if you created your planning when you had minor children. Your trustees aren't going to be your children. They might be your friends, your siblings, maybe even your parents. So as time goes on, obviously you're going to want to change that when your kids get older and are adults. So that's a common one with your personal life. Or obviously if throughout your life you have wrote out a child, or you specifically left a child out as a trustee, right? And life goes on and things get better, and then maybe you want to make sure you get them specifically put back in to inherit or be a part of and be a trustee. So things like that are happening, you always want to make sure your plans are good with your personal decisions and things of who you want in charge when you can't. And then your assets. So your assets, they're going to change over the years, and obviously with farmland, you have your values have really changed with that, with the fair market value really skyrocketing over the last couple of years. So that has put a lot of people into taxable estates. So that's something to also pay attention to and keep your assets updated with the values. Is, are we a married couple? Are we over $6 million as a married couple together with all of our assets? So when you pass away, you can have $3 million each individually that you can pass away with 0 estate taxes. But if you're over that, then you'd have to pay estate taxes to the state of Minnesota. So that's something we watch out with keeping your asset list updated. Another thing with that, and another big reason why most estate plans don't work, is you don't transfer your assets to the trust. You don't fund your trust. So once you sign a trust, it's not valid until you transfer assets to it. And of course, if we have any assets that aren't in your trust when you pass away and they're in your individual name, are we going to have to worry about probating that asset to get it to your kids? And that's one of the main goals why all of you did a trust plan, is to help avoid having to go through probate with your assets to get it to your kids, because it's expensive. It takes a long time, right? So that's another really big thing. And keeping updated, making sure your assets, as you accrue new assets, you're getting them either put in your trust now or having them set up to go to your trust on death. So when you're in life plan, like I said a couple weeks ago, we help with that. So let us know, update us as you get new assets. And you have your trust ID cards in your book that later on in this presentation, when we go through the book, I'll point those out again. So you have your name on it. So you can, when you get new assets, buy a new car, you can get it titled right in the name of that. But of course, we're here for you if you get an asset, a car, land, and you have it in your individual name. We're there to help you at no additional charge, then get it set up to your trust. So just remember that as years go on, is some assets can kind of slip through and forget to get in a trust, and that might end up being problematic with probate. And of course, doing a trust plan, having an estate plan that works, it helps with the costs on the back end when you pass away, right? So it costs a little bit more on the front end, but by doing an estate plan and keeping it updated in part of our life plan program, you're making sure that you are keeping track of the values of your assets, making sure that you're not over the $3 million, or doing what we need to do while you're alive to try to get 0 estate taxes. Another thing with trust plans is protecting your assets from the nursing home. So we now have the ability to get them into an irrevocable trust, your assets, because most of you have the living revocable trusts. By just having your assets alone in those, don't protect it from the nursing home. We have to utilize the gifting power to gift it out into these irrevocable trusts, Medicaid Asset Protection Trust, to get it to the kids early so we can protect those assets from being sent down to the nursing home. And then, of course, keeping your plan updated, keeping your assets in your trust helps avoid those probate fees on that as well. So I was talking a little bit about probate already, what it is, and I think most of you probably know, but the court process that you have to go through when you pass away in Minnesota with assets in your individual name. That is real estate of any value or other assets over $75,000. So, of course, married couples, if they have assets that they hold jointly, it just goes to the survivor. So on first death, you aren't having to worry about probate because those assets automatically go to the survivor. But then we have to worry about when the survivor passes away, do we have a bunch of assets in their individual name? We want to make sure that those are in the trust so we don't have to worry about probate. And of course, those assets that retirement plans, life insurance, those are already set up beneficiaries to hopefully the trust is what we want. And it still goes to your kids through the trust. A lot of people say, well, I want my kids as beneficiaries on my life insurance policies. And I say, if you have the trust, it's still going to go to your kids just the same as you had them listed as individual beneficiaries. But the benefit of that is when you have it going to the kids from the trust, is that life insurance then can pass to them protected. So those protected trusts that you all have set up for your kids and your trustees, that once they inherit from you, they're inheriting in a protected trust that protects their inheritance from divorcing spouses, creditors, catastrophic illness. Okay, we talked about wills a little bit too, and the thing with wills is even if you have a will and your assets are in your individual name when you pass away, they have to go through probate, that will is going to have to go through probate. I've had a lot of people ask me, so even if I have a will that says, here's who's in charge, my assets are going to my kids, it might still have to go through probate, and I say yes, if that asset's in your individual name. So keep that in mind with wills, they would still have to go through probate if needed to be used for assets in your individual name. And then another traditional planning thing here is living trust, like I've been talking about, and why estate plans don't work, is living trust with no updating, right? Not updating your personal, your finances, making sure it's updated with the laws, because then all of a sudden you pass away and do we have assets, we get a probate, did we not, update things to make sure we can protect assets from the nursing home and things. So, what is a trust? So, again, this is probably a nice refresher for clients as well, but for the trustees and the children. So a trust is like a bucket. And like I've been talking about, is a trust is no good unless we put our assets into this bucket. We need to actually transfer ownership of your real estate, your bank accounts, stocks, bonds, retirement plans, life insurance, all of that. We want to make sure that those assets are transferred to the trust for sure on death. So what we've been doing over the most recent years is we have been transferring assets to clients' trusts on death. Because if we've transferred it to their trust now, changing ownership, which is the ideal way and what we would prefer, it creates hassles for our clients. So with bank accounts, they want you to get a new account number, new checkbooks when you change ownership. So we say, no, we don't want you to have to get new checkbooks with that name on there. So we just help you get your assets set up payable on death to the trust. And by doing these, we need to do these while you're alive and well, of course, because when you pass away, we need to already have that designation that's in place that says it's in your trust then. So part of the process when you set up your trust plans with us is that we have helped you fund your assets that you had when you first came to us to set it up, to get it payable on death to your trust, or a lot of you have been with us for years, you probably have assets that are in your trust now, and that's okay. So we have clients that are gonna have assets in their trust now or going there on death. Either way, that's how we want it. We wanna make sure we don't have any assets that aren't in there now or don't have that on death designation. Okay, and of course, there's different types of trusts. So we've already talked about the living revocable trusts and the irrevocable trust that we can do for nursing home protection. There's also testamentary trusts that are created from wills. And of course, we don't like those because it just says with your will, it says on death, then it creates a trust like maybe for minors. I see so many wills that don't have their assets passing down to their kids in any sort of protected trust. These testamentary trusts are typically for if we got kids inheriting under 21 or 18, we want it to go into a trust until they're the age we want them to be, and then they just get it outright. And so that's the downside of these trusts created by the wills is we don't ever want it just to go outright to our kids. We want it to go in those protected trusts to protect their inheritance. The living revocable trusts that all of you have, you can change them at any time. You can redo them, revoke them at any time that you're alive and well. And you're in total control. It's not like everyone hears, oh, we have a trust. Trusts are bloodline protection, which ours are, but you can't touch them. You can't do anything with them. You can't take out, that's not how your living revocable trusts are, because while you're alive, we need you to be able to have access to your assets and be able to change things as your life changes. So these revocable living trusts give you that total control, and with having the assets being transferred to your trust on death, that really makes it stay as normal for our clients as possible, because then the ownership of the assets while they're alive and well is still in their names, in their individual names, and they still have the same access like as married couples as they did when they came in. So really things stay as normal. If they do have assets in their trust right now, yes, that does create some extra things that you have to do if you sell land or trade your car and things. You're going to just have to show them that certificate of trust for your trust, which will go through in your book too. So you do have to have some extra documentation when you're transferring out of a trust and selling assets. The irrevocable trust can be changed, and like this, I'm going to just use this Medicaid Asset Protection Trust as the example, since we can do them again now here in Minnesota to protect assets from the nursing home. So when clients do a Medicaid Asset Protection Trust, this irrevocable trust, they cannot change it. The clients, the trust makers, the ones who are making these trusts, they cannot change it. They cannot have control over the principal of the assets that are in these trusts. So we'll take farmland for an example. Most people are putting farmland into these Medicaid Asset Protection Trusts to protect it from the nursing home, but they lose their control over that land. They cannot, they don't have the say in any decision making anymore of selling it or how to maintain it and things like that. It goes into this trust, and the trustees then, which are going to be similar to in your living revocable trust, you'll probably keep the same trustees. Your kids are then going to be in control of this farmland while you're alive, while you have it in this irrevocable trust that you can't have control over anymore or change. So you have to be willing to lose that control over the asset when you put it into these irrevocable trusts. The trustees are typically your kids. They're the ones who have the control, can make the decisions, and they're the ones who are going to be the lifetime beneficiaries. So with trying to protect it from the nursing home, the idea is that we're trying to get assets out of your name and to your kids early, so then that way your assets are down to almost nothing, right, to get you on medical assistance to pay for the stay at the nursing home, so all your assets don't have to go and go to the nursing home and nothing goes to the kids. So with that, you can, question?
Can the kids have control right away before your death?
She asked, can the kids have control right away before your death in this irrevocable trust? Yes. What you're doing is you are gifting like this farmland into this trust now while you're alive, and the kids are going to be the trustees of it that yes have control of this land then. The nice thing about these trusts though is that you can still, the clients, they can still keep the income if they need to. So the land is owned by the irrevocable trust. They don't have control over it. The kids do, but they can keep the income still coming to them if they still need it to get by with expenses and things. So that is nice. But if you go into the nursing home, that income then that you're getting, that has to go to help pay for the nursing home, and then medical assistance kicks in and pays the rest. So that's the downside, right? Any access you have to any of the income of this trust, it's going to have to go, it's going to be available to the nursing home. So if you can swing it, and maybe when you're getting closer to, if you know you're going into the nursing home, you can stop getting that income and you can protect that income as well. And then you're not having any access to income in principle, it just stays in the trust with the kids, and you're able to protect that amount of money as well. And so the idea for it to be an unavailable asset for medical assistance is like I've been saying, you can't have any availability to the principal for sure, and whatever availability you have to income, they're going to count it. So you can't get any distributions or anything out of this principal and just go in and, because you can put retirement plans or things into this trust too. It doesn't just have to be farmland. Question?
Can kids, out of the goodness of their heart, gift you money then if you have no access to the trust?
He asked if the kids can then gift back the parents some money out of that trust then if the parents have lost.
It would be out of their income because the trust pays them, or...
Right, like if the income from the farmland is going into the trust.
Okay.
So if that's going into the trust and you're not having access to the income either, obviously they're using that income to be able to pay the property taxes, any other maintenance and insurance. And so the kids are the lifetime beneficiaries then. So if there's any income left over after expenses, they can distribute out to themselves. And so we have to be careful about you having access to distributions and things. We say that if you need any extra assistance, we just tell the kids, yes, you can make distribution out to you and maybe pay the nursing home directly, or get something for your parents directly from that rather than going back to them and things and creating that trail. So yes, that's something. You cannot be a lifetime beneficiary and get distributions out to you because it's going to be an available asset from the nursing home. Your kids are the ones that are the lifetime beneficiaries of this. And remember, this is the irrevocable Medicaid Asset Protection Trust. That is not the living revocable trust. We have a question back here first, and then I'll come up here.
How long do you have to have it in this irrevocable trust before you enter the nursing home?
She said,
usually isn't there like you have to have it in so long?
yes, she said, how long do you have to have it in this trust before you enter the nursing home? So there's a 5-year look back for medical assistance. So if you put your assets into this trust and you need to go into the nursing home in a couple of months, that's okay. You're still going to be able to go to the nursing home, but you're going to have to pay out of pocket, and you're not going to be able to get medical assistance to pay for your stay until 5 years after gifting into this trust. So that is something that we have to think about too with these trusts is it still a gift when we're gifting this to the kids? So we still have to wait the 5 years, and we got to make sure that that is doable with your situation. Do you have enough assets to pay out of pocket if you need to, if you go in within the next 5 years? Are you going to live 5 more years? Things like that. So yes, 5-year look back with medical assistant. I know I had here and here.
What about put real estate? Do you lose the stepped up basis?
Good question. He said if you put real estate in this irrevocable trust, you lose the step-up basis. Because yes, the general idea was anytime you gifted anything to your kids during your lifetime, you're also gifting them your basis. So they don't get a step-up in basis, and then if they were to sell it, they're going to have crazy capital gains. So the great thing with these Medicaid Asset Protection Trusts is the way we can draft them is we can keep that step up in basis. So that's something that is great that we can do this now rather than gifting into their individual names where we lose that step up. We get to keep a step up in basis. So meaning that even if we gift into this trust while you're alive still to the kids, we can keep that step up so then if they resell it later, they're not looking at crazy capital gains. I think I have one over here.
How long after the death of the original parents do they have to dispose of all the assets in the revocable trust?
So the question was, how long after the death of each parent do they have to dispose of or distribute out assets from the living revocable trust? So the lawyer answer is it says a reasonable amount of time. So there's not like set amount of months or years that you have to get it out of there. So there's a process, and we'll get to it in some slides later too. There's a process that we like to do that we still have some to-dos on death for administration. So it still takes a little bit of time before we might be able to get to the point where we're distributing out to the kids. On first death, that process happens very quickly. That doesn't take long. The other spouse is still going to be a trustee, likely, of those assets. So their access and stuff is going to stay the same to that on first death, but it may take a few months on second death to get things actually distributed out to the kids, because there's probably going to be deed work and things like that. We need to make sure we're getting appraisals done of land, getting data death values. So there's not a set time, because that can vary. So it's a reasonable amount of time, and it's the beneficiaries of the trust that could say, hey, and you're going to hear this in slides later, because the trustees have a duty to the beneficiaries. Beneficiaries could say, hey, what are you doing? This is taking too long. They could have a right to sue and make it go faster, but there's no set answer to that. Yep, and I had one over here. What if you have your land in an LLC right now? As far as for medical assistance protection. So having your assets in an LLC, because a lot of you do have the farmland in the LLC for the estate reduction. So by having your assets in your land in an LLC, that doesn't protect it from the nursing home either, like your living revocable trust, right? It's going to be counted as an available asset to you. You would have to gift shares out of that into your kids early within the LLC to then protect those shares of the land that's in there. But with an LLC is that, again, when we're gifting shares to our kids while we're alive, they get our basis, they're not getting a stepped up basis. So it's something that I've been telling clients, come in, talk to me. It's something we need to talk about in depth of, if we have things in an LLC, how are we going to protect these assets now that we can do these trusts? So keep that in mind. Just in the LLC doesn't protect it either. We have to do some gifting and come talk to me to figure out what is the best way to do that. Is there any other questions? There's another one here.
In a local trust, it's its own entity for every year taxes and federal, state, whatever. And then on top of that is made a comment that out of that trust, the trustees could gift to the rest of the beneficiaries. So that could gift stay underneath a certain value of that gifting.
Right. So the first thing is these irrevocable trusts, are they a separate entity? And yes, they are. They're going to have to get a separate tax ID number, and they are going to have to file a separate tax return for the trust. And so keep in mind, any income coming into a trust, there's a higher tax rate than the individual tax rate. So keep that in mind, because some people forget about that, and we're leaving income in a trust every year and then we're paying crazy amount of taxes. So then into his next question is distributing that income out then, like to the kids, and if that, in gifting, if they were gonna give it to other people. So the first part of that is they want to distribute out as much as they can. Obviously, they're not going to try to just dwindle down all of your assets in there, but what they're doing is they're going to make sure they're paying for all the expenses for the assets that are in this trust, like the land, out of that income in that account, and then yes, making distributions like out to themselves to help with those taxes. And so them as the lifetime beneficiaries, yes, they could gift it to other people, but remember with these trusts too, we're still within the restrictions of the trust and how you want them to distribute and have these assets. So within your trust, there might be some rules and restrictions on who they can gift to and things, right? What they can do with your assets. But yes, his next question is they have to worry about a gifting limit. So yes, right now this year anyone can gift up to $17,000 per year per person. If you gift more than that, you're gonna have to file a gift tax return, and you don't have to pay taxes, because right now you have a $12.92 million lifetime gifting exemption. So the idea is yes, you can gift more than the yearly exemption, but you're going to have to file a gift tax return. You're not going to have to pay the taxes. Next year, the gifting exemption goes to $18,000 per year per person. So again, when you gift more than that, you've got to file the gift tax return. And remember that each parent can gift $18,000 to each kid if you're trying to maximize that. And then the federal exemption, right, that says when you pass away, that's where it gets us our gifting exemption. So the federal estate tax exemption of that $12.92 million, that's how we also get our lifetime exemption. So for next year, the federal estate tax exemption is going up to $13.61 million. So then that means your lifetime gifting exemption also goes up to $13.61 million. So that's great, and we have plenty to be able to gift without paying taxes. Any other questions before we move forward? Yep. Okay, so he said that I had mentioned that the Minnesota state tax is $3 million per person, and he said, what is that tax rate? What are you paying if you're over that? So it starts out at like 10%. And the average that has been over the last couple of years is in like the 13 to 16%. What you have to worry about is the federal, because if you're over the 12.92 or the 13.61 next year, is then you're taxed at like 40%. So that's the one you really have to worry about. And luckily it's so high, most of us are okay, but remember, they're predicting it to sunset and go down the federal exemption to $6 million per person in 2026. So that's when some people might really have to worry about the federal estate tax exemption with those 40% tax rates. Okay, so then quickly some other trusts is to give the trustees and the kids an idea of the tax planning that we have built into our living revocable trust. So we have the 2 living revocable trusts when clients are alive. I'm going to go back over here because I think our video is over here. So we have the 2 living revocable trusts when the clients are alive, that they're both trustees of, and maybe one of the kids is trustees now if they need a helper, that they both have access to that full control. So then when one passes, it's going to go down into a family trust is what it's called for this tax planning. So the living revocable trust with half of the assets in it of the first deceased spouse goes into the family trust. Irrevocable, can't be changed. So it gets confusing with these irrevocable trusts, but this irrevocable trust is different than like the Medicaid asset protection one I was talking about. This becomes irrevocable on death of whatever's left in their living revocable trust. Has to get a tax ID number, file a tax return. But the way that we have it set up for almost all of our clients is that the surviving spouse is still going to have access to this family trust. They're still going to be a trustee, likely, and they're going to be a trustee with one of the kids. Because the clients have it set up that while they're alive, they say, here are going to be my trustees on death. And it's typically spouse and one of the kids, and other kids as backups, or other beneficiary or other trustees that they may have chose. So that's another step of it too with that irrevocable trust. So then when one dies, we have assets in a family trust, and we still have assets in the living revocable trust for the other spouse that's still alive. And then when that spouse passes away, we're not going down into another fancy name trust. We're just then distributing to the kids from the family trust and the other living revocable trust. Again, I know all this is super complex stuff, and trying to follow my air hands. I draw it out in diagram in person. So obviously take advantage of your free phone calls if you need me to explain this anymore. If you would rather sit down in person to have me explain it, draw it out, it's charged hourly, but just know that you can do that too, because sometimes a lot of this is hard to follow with these different trusts. Okay, so what is a trustee? A trustee is a person or licensed corporation that owes a special duty of care to the beneficiaries of a trust. So trustees can be individuals. Like I said, most of you are going to have individuals as your trustees, and they're going to be your children. But if your children aren't a good option, or you don't have any children, you only have one child, and we like those backups, you can also have a professional as a trustee. And so you can have an attorney, you can have an accountant, a financial advisor, someone like that, and that's who I would recommend, because those people are going to charge hourly then for anything they do as a trustee. Whereas if you go to these big trust companies and corporations to be a trustee, which you can, they're going to charge you a certain percentage each year, even if they're not doing anything. So just know that, though, that you're not always tied to individuals. And a lot of people sometimes panic when I say, okay, we want these 3 trustees, we want these backups that you can choose, so then we have the backups that you've chosen, and we don't have to go as default if we run out of people. So some people panic, and I say, well, you can do a professional, and some of you might have Hannon on yours as a trustee, some of you might have me. So that is something that ethically we still can do and be a professional trustee on your trust if need be. But most of the time, obviously, we're like the third backup or down there, and that's what we recommend. But if you need another backup, it can always be me too. I was going to say something else with that. Maybe it'll come to me. So a trustee is in a position of trust, service, and loyalty, of course. So they have the fiduciary duty to act in good faith, and they have to follow the rules of the trust and the powers and things that are within it. And so they have this duty to the beneficiaries to act in good faith. So like I mentioned before, is if they're ever not following the trust rules or doing something that's not in good faith, the other trustees can hold them liable, but so can the beneficiaries of this trust. They can hold them liable for not acting in good faith with these assets. A successor trustee. So these are these backups I've been talking about where typically in your trust you're going to have spouse and a kid, and then our successor trustees are our backups, which you'll probably list your other children then as backups. So they are the one who takes over for the previous trustee when they are no longer able to perform as a trustee for whatever reason. So typically we're saying on death it's spouse and one of the children. But on death, most of you in your trust are requiring 2 trustees at a time, co-trustees to be helpers, checks and balances, and so we always want that 2 at a time. So then obviously if that second spouse, when they pass away or if they become mentally incapacitated, then your child that you had listed as the next option then jumps up as the first child that was with you, and then they're the co-trustees then. So that's why it's important to have these successors, so then we already have a plan right away of who's automatically gonna bump up if someone's unable to, incapacitated, passed away, or just don't want to. A trustee can resign. They can say, no, I don't want to do this, but they have to give a written notice to mom and dad, the people who made the trust, and to resign, and then it would go to the successors then as well. We talked about you're going to name them in there. It's not uncommon to have 2 or 3 successor trustees acting at once. So we recommend the 2 trustees for a helper, the checks and balances. But remember, unless you've stated otherwise, when you have co-trustees, only 1 trustee is required to act. So if you have spouse and a kid, they both have full control and access to the assets in the trust at that time when they become trustees, and they don't necessarily have to have the authorization each time to go do things, which is great if you're a spouse still a trustee after the first death with one of your kids, because if you're still of sound mind, you're wanting to still carry on with your business and your finances, and you may not always need your son or daughter to help you, but they're there to be able to have access if you need their help. So then that way you don't have to go to your child every time you need to do something, and vice versa. But know that some of your plans might say otherwise, right? You can say that 2 is required to act. So always look back and refresh on that to see what you have, but most people have that when you have co-trustees, they can act independently. And I'm typically recommending against 3 or more trustees at a time. We have some clients who they struggle trying to choose between their kids, and so they'll just say all the kids and the spouse. And that's fine. It's just obviously the more people you have involved in making decisions and things, a little bit more muckier it can get, and maybe some issues and fights happen. But you obviously can do that, and typically we might have both of the spouses and one of the children, so we might have 3 there. And so, that's okay, but when you have like all of the kids right away and all of them are involved, it might get messier, but you can certainly do it if you want to. And they count to the beneficiaries. Types of trustees, we've already talked about this, so I'll go over this really quickly. You can have individual trustees, families, friends, loved ones. That is what almost everyone chooses. That's the common option, and that's the option we recommend. But you can choose the other professionals, attorneys, accountants that charge hourly, and then you can do the banks and the trust departments, but you have those annual fees. Okay, so how does the trust work at each level when the clients are alive and well, when they're mentally incapacitated, when they pass away? How does the trust work? What are the duties of the trustees at that point? So when the trust maker, the parents, the ones who've created these trusts, when they're alive and well, they're going to be a trustee. And so on these living revocable trusts, the spouses are going to be trustees of each other's trusts. So then no matter what trust it's in, each spouse can still have the same access that they had before and be in control of their assets the same. Sometimes though, you can be alive and well and you can have your children on as trustees now too, just there as a helper. But remember, you don't necessarily have to. We do have it set up in your trust in Article 4 on mental incapacity, who are the trustees that you want to take over. So we have that already planned out, or if something happens to you, here's going to be the trustees that take over, and this is then when you have the kids that start jumping up to be trustees. So when a trust maker is disabled, mentally incapacitated, then that's where you're typically going to have the other spouse, if they're alive and well, and one of the kids on as the trustees of the trust of the person who's mentally incapacitated. Now, too, if one's become mentally incapacitated or once one dies, we're typically telling the surviving spouse, you might want to just appoint that same child as a co-trustee on your living trust, even if you're still alive and well, as a helper. So sometimes we'll see that too. And we can walk you through that when, we have meetings with you on incapacity and death. We walk you through, okay, here are the trustees now, and how we recommend the surviving spouse to have the trustees on their trust. After the trust maker has passed away, we're going to have spouse and kids. Kids is the backups. But when both of you are gone, it's 2 of the kids then, if we have 2 at a time, are going to be trustees of both of your trusts when you're both gone, with maybe other kids as the backups. So that's when, on death, when you're both gone, that's when we're typically having a spouse not as a trustee anymore, and it's the children who are the trustees. Okay, so a little bit more about Article 4 in the trust of mental incapacity for the trustees and the children here today. So that is a detailed article that says how your parents' trusts are going to be handled on mental incapacity. And they've already set up in their trust a definition of when they're going to be deemed mentally incapacitated, and they have this panel in there in Article 4 that likely includes all the spouse and the kids of who can decide whether they meet that definition and whether they're mentally incapacitated or not to be removed as a trustee. So that's another spot in your trust that you'll find the children's names usually to be able to make a decision. But that is only to say whether mom and dad are mentally incapacitated and should be removed as a trustee. This is that disability panel in Article 4, and when we review the trust towards the end of this, I'll point that out as we flip through. Disability trustees, what are your duties? So if you become a trustee on disability, mental incapacity of one of your parents, contact us because we can help you, we can walk through it. Yes, in their trust, they have already in there, here are backup trustees. However, we do have to create a new certificate of trust is what it's called, to show who the new current trustees are now on mental incapacity, that they sign and notarize, that they make copies, these trustees, and give it to the banks and places. So then banks and other places, your financial advisors, insurance agents, then they know that they can deal with one of the kids that on mental incapacity. So you always want to let us know too, because yes, it's automatic, but we still have to get that document for you to show that change. And you also want to be contacting your financial advisors, accountants, to see if there's any other planning, any other things you need to be doing. Because if your parent's mentally incapacitated, they're not able to make decisions on their investments and things anymore. Now as a trustee, you're able to be in control and be in control of if you should move any assets because they're getting interest elsewhere. So that's something too. You always want to make sure you're being in contact with the financial advisors and accountants to see if there's anything you need to do with investments and things. And the disability trustees are going to serve until the trust maker is recovered or passes away. Question?
If an individual recognizes in themselves that they may no longer want to be a trustee, like a parent, they just don't feel comfortable with the memory or whatever, can they say, I want to do it myself and not necessarily go through the disability process, or does it have to actually go through that process?
Yes. So she said if a trustee or, whether it's the trust makers as trustees or even someone else as a trustee, if they are realizing themselves that maybe they're slipping a little bit and they can, yes, decide to resign. As long as you're alive and well, you can say, yep, I'm just going to resign as a trustee, give written notice, and let the kids take over without having to get to that disability part. So yes, and that's something too, that the trustees, the kids can be proactive in calling me too and being like, okay, mom and dad, they're starting to slip a little bit. They've mentioned that they just don't want to be in charge of their finances anymore. Then we can work with all of you to help prepare that document for them to sign and resign and not have to worry about the disability panel. Another thing is your common law power of attorneys. Who takes over on mental incapacity for your power of attorneys. That obviously reverts back to, it says immediate for spouse for almost all of our clients, but it doesn't go to the kids until disability as defined by your trust and that panel. So when you're removed by your panel as a trustee, you're also removed under your power of attorney, and the next one takes over under that as well. So to avoid that step for your power of attorney, remember, and we'll go through this when we review it, is you're going to have at the very last page of your power of attorneys, it's going to be called a certification of authorization of principal. So that is a document that mom and dad could voluntarily sign when they're still alive and well to voluntarily turn it over to the next person under their power of attorney without having to go through the disability panel. What you have to keep in mind though is if they're going to sign this certification of authorization, and it does have to get notarized, you don't necessarily have to facilitate coming to me, or we don't always have to know you're doing it. We'd like a copy once you're done, but you can just go to a notary at the bank and get it done when you want to. But something to know is that if your other spouse, if your spouse is listed as the next in line, and you're signing this certification, turning it over to them, it's just turning it over to them again, that they already have that access to, unless they have signed a resignation, they're incapacitated or passed away. So keep that in mind, that this certification is typically for when you want to voluntarily put a child in charge, and this is going to be when the other spouse can't do it anymore or wants to resign. So those are a couple options, yes, that you have to not even go through the disability panel that are there to even create less hassle. Okay, so then in your trust in Article 3, after the incapacity trustees, we say who are the trustees on death. And that's when the disability trustees stop serving, and then we gotta follow the trustees on death. But don't panic, it's usually the same list. Sometimes there might be some clients that have a different list for certain reasons, but almost all of our clients are gonna have the same list of trustees on incapacity and death. Okay, so a little bit more about disability trustees quickly is what they want to do when they become a trustee on disability. Read and follow the trust instructions, because in Article 4 there is some basic general rules that we say that the trustees have to do is take care of mom and dad, pay their bills, do whatever they need financially, take care of any dependents they might need, or they might be financially caring for at the time. Typically, that's not going to happen if they don't have minor children, but some clients will have in there, take care of our minor children on incapacity until they're 25. So keep that in mind. You'll find that in Article 4. And then you have to pay attention to, as a disability trustee, there might be some specific rules in there on incapacity for mom and dad's assets that they want you to do or don't do. So this is usually where you're going to find the farming provisions on mental incapacity, is who do you have to rent to now that dad can't make the decision of who to rent to, or he's not farming anymore. Who do you have to rent to, at what rate, who has the free use of machinery, tools, and equipment, right? And so this is where if there's farming heirs, or there's been a renter that dad has rented to for years, this is where they're going to have that in there to make sure that farming heir can keep renting at a low rate before they inherit when both of them are gone, or to make sure that renter that's been there can keep renting. So that's something as disability trustees you want to pay attention to, because there might be some specific ones to their assets they want you to follow. And you always want to have a good idea and inventory of the assets. When you become a disability trustee, you want to know what assets you're working with, that you're in control of. And our clients should always have a asset list, a spreadsheet of all of their assets. And it's going to have what kind of asset it is, what bank, what financial advisor, what county is this land in. It's going to have all that information on there for you. Except our asset lists don't necessarily have, here's the phone number, or here's our agent name. Sometimes it does. So I do recommend clients to maybe have a separate page in their books with all that contact information too, of the phone numbers of these companies and the names of the people, and have that just there for them too, that we don't have on the asset list. So keeping an inventory of the assets, and maybe you see, oh, we need to get something to the trust or something like that. So always look over those assets, and you want to maintain, preserve, and secure the assets, manage the assets, and make investment decisions with key advisors. So keep in mind, when you're a trustee, you have all the power and controls over the assets that the trust gives you. So you're typically going to have all the same powers and controls that mom and dad had, except for you can't amend the trust or things, but you can buy, sell, trade, invest with assets if the trust allows it. Obviously, you have to pay attention if the trust says that you can't sell any farmland or things like that. But know that when you become a trustee, if you want to move some money out of a bank account into an investment account that's getting better interest, you could do that for mom and dad with their asset. Obviously, pay bills, provide for care, keep records and document transactions and business activities, pay taxes and estimates. You account to the beneficiary still throughout this whole process, and you're going to want to communicate with the trust maker, advisors, and beneficiaries. So if you're a disability trustee, but your parent, still has some sound mind, some moments, or they were just take over, I'm fine, but take over. You always still want to communicate with them and make sure they know what's going on and involving them in the decisions where you can, if they're able to. And obviously you want to, be communicating with the surviving spouse that is, or the other spouse, I should say, before the first one goes, communicating with that other spouse, that other parent as well. The death trustees, once the trust maker dies, like we talked about, what the trustees need to know is then that trust, whether it becomes the family trust on first death or just the living trust on second death, on death, those trusts are now irrevocable. When you're the trustees of that, you have to pay attention because we're going to be stuck with what mom and dad have put in there. Can't make any changes unless they've given you some exemptions or exceptions to that. So, like a power of appointment. A lot of you might have a limited power of appointment on first death for the other spouse to be able to change some things. And then when both of them are gone, and it goes down to the kids and their protected trusts, you might see that limited power of appointment again, where the kids can then change where it's going, but it's limited, and they can only change it within mom and dad's descendants. So keep in mind, on death, irrevocable. You're going to be stuck with what they have typically. You're only likely going to be able to change things within mom and dad's family. Contact our office right away. So you certainly can. You don't need to get an appointment with us right away. We say, take the time to grieve, get through the services and things, settle down, and then you can make that administration appointment with us, we say around 30 days after death. But obviously, we like to know right away. We send out some sympathy cards and things, so you could just give us a courtesy call right away, but you don't have to jump in and have the meeting with me right away to go over all the to-dos and things. Obviously, for trustees, if there's any issues with having access to anything, paying bills or anything like that on death, call us, because we can do things to get you that access, like getting you a tax ID number right away, getting you a certificate of trust right away to show the banks, hey, I'm a trustee now, I can have access to these accounts to pay bills. So contact us right away if you have those issues, and we can facilitate getting those to-dos done right away, but we don't have to jump into the big old meeting with all the other to-dos. On death, don't do anything with the assets, right? You want to wait to talk to us after the first initial meeting. We're going to guide you then on first death, second death, what needs to happen with these assets. So don't do anything until you speak with the attorney. And like we said, don't rush the family. You can allow their grieving time. You don't have to get this appointment with us right away. But obviously, if you have emergencies and need to involve us right away, do that, and we'll help you. One of the bills that you're going to have right away is the funeral expenses, and so that's one that is typically already even paid when clients come in to meet with me. So that's one that trustees are going to have to make sure that they pay, is the funeral expenses. And our clients either have they have life insurance policies that will help cover those final expenses that you'll have access to on death to pay that. Or what we've been recommending a lot of our clients to do is to set up and do those pre-funded funeral policies where they can pre-fund it. And then the reason I say that instead of prepay is because obviously when mom and dad are going in there, they're picking out their services, everything they want, and they get this total of what it would cost at the time they're picking it out. So then that's what they're pre-funding that it's going to pay for. And so depending when they pass away and inflation, is it still going to be that same amount, right? So keep in mind with that, with these policies, is maybe you children as trustees might have to pull a little bit more out of their estate of checking accounts to add to these funeral policies. But typically they're going to be there to cover a big chunk of it or all of it. So it's something that we recommend, so then that way it is just taken care of and paid for, and it allows the spouse and the kids to grieve and not have to make all those decisions with your services and what scripture, music, and all those kind of things. And another big thing about these pre-funded funeral policies is that when you do them when you're alive and well, and if you need to go into the nursing home and we're getting assets out of your name and we need to get you on medical assistance, having these pre-funded funeral policies is an unavailable asset. So it's something that we don't need to get out of your name to qualify you for medical assistance. So sometimes, for medical assistance planning, we need to get assets out of your name. We got to get life insurance out of your name. Cash value of over $1,500 needs to get out of your name. Obviously, while you're alive, that death benefit's not available, but if that cash value is gone, is that death benefit still going to be there? So that's something when we get into medical assistance planning is we might not be able to always bank on having life insurance policies or monies in investments anymore to pay for those expenses on death. So having that prepaid, pre-funded funeral policy knows that it's taken care of and it's always going to be there, even if they got to do medical assistance planning. Okay, schedule a meeting within 30 days. If you want to do something, I realize a lot of people, they want to stay busy after this, they want to keep things going, they want to make sure that everything's in order and organized. With the funeral home, they're going to help you order the death certificates. So that's something that our office likes a copy of. And you're going to need death certificates for all of the assets. So for the financial advisors, life insurance agents, the bankers. So, you want at least around 10 death certificates when you order them with the funeral home. And what I typically tell clients is and trustees is if you're looking at this asset list, look at these different companies and you're going to want to get a death certificate for each company that they have an asset with. Obviously, if they have 4 bank accounts at Bank of the West or BMO now, you don't have to get 4 death certificates. For that, you can just, I got one for BMO, right? So that's a good way to make sure you have enough death certificates too, is looking at their assets and figuring out how many you need. Gather the statements, find the trust book. Another big thing that you need to be doing right away is the surviving spouse or the trustees on death is calling Social Security. And you need to have the Social Security payments stopped because we don't want you to run into an issue where they didn't know right away and they keep putting those automatic deposits into their account and then they're going to say, they passed away. You have to reimburse us this money that we paid after their death. So you don't want to have to mess with that because as you probably know, that's not going to be an easy process to facilitate getting that done and things. And sometimes I know I've had a lot of clients will say, yep, we called them and we had just gotten a deposit, but if you call them within enough time, I think, I don't know if it's like a certain amount of hours or a couple days, they can just pull it back out of the account right away without having to facilitate all that reimbursement back. So if you can get them called right away after deposit, they might be able to pull it out right away. So keep in mind those things, especially if all of a sudden you got the Social Security money and you need it, but it's got to go back. So pay attention to that. Gather the life insurance policies. And so these are things that, like I said, you can be doing before the initial meeting that you have with me to go over the rest of the to-dos. So the first meeting, what can you expect? So this is the first meeting, this initial administration meeting for the trustees, the surviving spouse, the kids. There's an administration meeting on each death for the to-dos. So what you can expect is I'm going to worry about how is the surviving spouse doing, how are the kids doing, how's the surviving spouse doing financially, are there any emergencies with paying bills and expenses, usually one of the first questions that I'll be asking. So making sure they're good and they can continue to pay the bills. And this also might segue us into figuring out, based on how the surviving spouse is doing, it might already prompt a conversation of, okay, maybe we need to get the other child as a trustee on the trust, your trust for you too, to help you. So those are the first things. So the surviving spouse may serve as an administrative trustee alone or with a co-trustee. So like I've been saying this all along, on death, it's going to be the surviving spouse and a child, but maybe some of you just have the surviving spouse or just a child right away. So you always want to look in Article 3 to see how you have your trustees set up. The second meeting, what you can expect. So at that first meeting, we're giving you all these to-dos. I'm writing on my legal pad, here are the family's to-dos, here are my to-dos that we'll be doing in the meantime of the second meeting. And so the big things for the family is they're going to be gathering data death values, getting certified appraisals on the land, things like that we need to have done before we can move on to distribution and things. So at the second meeting, if the trustees don't live close, and this can even be for the first meeting too, I've done a lot of initial administration meetings over the phone first, and then maybe we do in person. So just know that we're willing to work with you. We can do these meetings by phone. We can do them by video chat. You know, however, I can come to you. So just like Hannon did, I still travel to my clients for appointments as needed to, or meet halfway or things. So just know that too. These don't always have to be in person, but obviously I realize it's easier to understand and know what you're doing if it's in person. But if we need to have trustees by phone or by video chat, some are in person, we can do that too. So forms are going to need to be signed. So that certificate of trust saying, here are the new trustees. The trustees are going to have to sign it and have it notarized. If we're at the point of second death and we're needing to distribute land out, or maybe it is first death, and some of you have on first death that some land goes to the kids right away and doesn't just stay for the spouse, so keep that in mind too. Again, we walk you through all of that. We go through the trust at that initial administration meeting to figure that out. Is there anything we have to distribute on first death? So typically when it's second death, that's when we're having all the deed signing, getting all the real estate transferred over and signed by the trustees, getting it transferred over to the kids in their protected trusts. And then getting these protected trusts set up for the kids. They need tax ID numbers. These are irrevocable, can't be changed. Tax ID numbers, have to get a certificate of trust showing who your trustees are, so then that has to get signed. So again, it's a lot, but we walk you through all of this in these meetings, but just know that the trustees are going to have signings to do on death that we can facilitate in person, or we can always facilitate by mail and things. When we're doing deeds and certificate of trust that have to go with deeds to record, we have to have originally signed signatures on each document. So that's where we might have to mail, and it might take a little bit more time in this administration process if we're mailing to trustees in different states and things, because we can't just have them print, sign, email back, right? We can with some of them, and we'll let you know that. But we will also let you know when we need things originally signed for recording. Okay, a little bit more about the second meeting. So on the first death, we were kind of talking about that distribution. So we're going to be doing some funding, some transferring of assets. So on the first death, we're going to be transferring from the living trust to that family trust. Or is it second death and we're transferring from the living trust and the family trust to the kids' protected trust? And I will say too, there's not always a family trust. Most of the time there's going to be. But if we have clients who pass away and they don't have large estates or anything, we just say, you know what, it might just be easier for the surviving spouse to just get all those assets in their trust, knowing it's going to count towards their estate, all of it. But where they're at, sitting at with their estate, it's fine. They aren't going to have to worry about estate taxes. So that is something I wanted to add to, is sometimes that family trust is skipped if we're not worried about estate taxes. Inventory assets. On death, you're going to have to worry about the last personal tax return as trustees that you need to file for the parent that passed away. The last joint tax return, or on both deaths, the last personal single one. And then keep in mind too that when we're going into these irrevocable trusts on death, the trusts have that separate tax ID number. Those trusts are going to have to file a tax return. So the trustees might also have to worry about trust tax returns as long as there's income coming into the trust. So the first year, obviously, you're just doing the personal return. You might have a trust tax return, though, as well in that first year that they passed away, depending on what income, when they passed away that year, and what income's coming into it. But obviously, moving forward on first death, you're going to just have a trust tax return then for the income that's coming into that family trust. And then when the second one passes, you're going to have a trust tax return for that one as well. But the good thing is that once we get assets distributed out to the kids on second death, then you're going to be done filing the tax return for mom and dad's trust, because there's nothing in it anymore to accrue income. You have to file those returns. But when it goes down to the kids in your protected trust, you then have these assets split up however mom and dad wanted it split up to you. You're reporting the income then to you and your protected trust. The protected trusts have to file trust tax returns. These trusts that you're inheriting. So trust after death always has to file a tax return. Right now, when you're alive and well, these living revocable trusts, they use your social security number to identify them. You don't have to file a separate tax return right now. You want to discuss tax issues with your accountant, financial advisor. You always want to be talking to them right away when you're talking with us too. And keeping track of any tax basis, step up in basis things. That's why we want the certified appraisal of the land on death, because that's what's going to get us the new basis. And so that has to come from fair market value and what the appraiser gives it. It can't just be what the value is on your property tax statements. And then obviously provide care as directed in the trust. If there's certain things that you need to be doing on death with assets and providing for other people. Okay. Now we are going to do a review of your trust book. So if you want to get that on in front of you and in front of your trustees and your kids, we'll go through that so then they have an idea of what's in there and where to find these things I've been talking about. Okay, looks like mostly everyone's ready here. So when you open up the book, these trust ID cards are going to be there in the back of the front cover. And so this is what I had mentioned earlier. This is going to have their trust names on it. So if they're ever opening new bank accounts, buying real estate, any new assets, right, they have this accessible to them right there with their trust names to make it easier for them to be able to put assets in the trust right away. Or if you're a trustee that you can also buy, sell assets, you have that there too, that trust name to be able to have. Obviously the trustees are going to change, so the long formal version of their trust names has both mom and dad as the trustees right now. Also keep in mind though that when you're funding assets, you don't necessarily have to have that long trust name. That is what we prefer, but in Article 1 of your trust book, it talks about how any name will do though. So you can shorten it up to just first and last name living trust. You don't need mom and dad as trustees of dad's living trust dated this date, right? You can shorten it, especially for like car titles and things. So just know those are there. If you flip it on the back, you have our information. Some of you might still have hand and sold cards, which is fine. Our number is still the same. But if you need new business cards, I think I might have a couple with me, so I can hand out some in the back if you want a business card for me. It will have my email on it. So feel free to do that. If I run out of cards in the back, contact our office, stop by and grab some. There's always some on the counter. Okay, then you've got the introduction stuff in your book, and I'm going to kind of look at yours too. So then after the introduction, there's going to be tabs too for easy finding for each document for the trustees to find. So right away, you're going to have the trust tab. And what you want to keep in mind with the trust is how we do this is if it's a married couple, we have husband's trust first and any of the other documents in there. Then we're going to have a purple page, or if you've recently done your planning with us, we switched to like a gold page. It's going to separate the husband and wife's documents to be able to quickly find each trust. So you'll have husband's first, a divider page, then the wife's documents. So in the trust, you're going to have a table of contents in there. So trustees, parents, the children, so that way you can kind of find quickly which article you need to go to. Because there's only a couple articles in here that have your specific detailed information, and the ones that you're going to be going back to refer back to often. So know that Article 3, that is a big one that you have to worry about as trustees. Article 3 is the one that says who are the trustees on mental incapacity and on death, and what are the rules for the trustees about that they can resign, if there has to be 2 at a time, things like that. So that is a really big one for you guys here as trustees, is Article 3. Then also in Article 3, trustees of the separate trust, keep in mind that's where it's saying who are the trustees have to be of these separate protected trusts once we go to the kids, because mom and dad might have said who they want as trustees and how that works. If if it goes to grandkids, they want them to be a certain age so they don't blow it. So that's in Article 3 as well. Article 4 is where you're going to find how their trusts are handled on mental incapacity.
14.
So at the very top of Article 4, that's going to be their definition of mental incapacity. And then under that, you're going to find that disability panel I was talking about. Now, all of those people listed in this disability panel, they all have to agree, unless clients state otherwise, but I don't think anyone really has that. All of the members of that panel have to agree that mom or dad have lost their marbles and need to be removed as a trustee. So all of them have to agree. So you're typically going to see a doctor there, a spouse, and kids. Okay? And then the rest of Article 4, that's where you're going to find the rules on mental incapacity, right? Take care of me, take care of my spouse. And then what you want to look for in there is after those rules, take care of me and my spouse, there might be some specific rules there before you get to the gifting about what mom and dad might want you to do for certain assets. This is where you might find farming provisions. Or I've had clients who have storage units, apartment buildings will put specific things in here for those assets. So take a look quick and see if there's any in there, and you might want to circle back and read through them later, but know that there might be some specific rules for you there. And then of course, this is where we have the power to gift on mental incapacity. So if mom or dad is mentally incapacitated, they can't gift for themselves, we're going to have that the disability trustees, one of the kids, can gift out of mom and dad's name if we need to, an unlimited amount, no matter what asset they have, to protect it from the nursing home, or if we need to gift it out of their name to bring them under a taxable estate. So this is another big thing in Article 4 is having that power to gift in there for the trustees for medical assistance planning. Then Article 5 is how trusts are handled on death. So this is the article, I'm not going to go through it today, but this is the article that I will go through with families on first and second death to say, okay kids, here are the to-dos for you, here are the to-dos for our office. Article 6 is personal property. So another article we have to worry about on death is on each death we need to go and look there, and we need to look at their personal property memorandum that is in the way back of their books, and we'll get to that too. But that's going to say if we need, you as trustees, if you need to distribute any personal property out on each death. So it's going to say, go to that memorandum in the back, and that memorandum in the back is going to tell you, yes, I want this gun or this ring, this hutch, or things like that to go to certain kids, and not necessarily it all just goes equally to my kids and they figure it out. So we tell clients, fill this personal property memorandum out. That's usually the cause of the family fight, is the personal property. So trustees, this is where we go back and we look, is there certain personal property that has to go to certain people? And we also have to look, okay, if dad passed first, does he want these things to go to these people even if mom survived him, right? So we look at, are we doing it on first death, or are we waiting till second death with some of these things? 7, 8, 9 is the tax planning articles. So we can really skip over these. This is where we're creating that family trust, and it shows that the spouse is going to be the beneficiary. They're going to have full access to it. So that's those. And then 10 is a big one to pay attention to, because this is how do the assets pass down to the beneficiaries when both mom and dad, both trust makers are gone. So this also, I should back up too, because sometimes in 6, I know Hannon would put some specifics about like land and real estate or other specifics about assets in Article 6 sometimes too. Now we've moved on to put them in Article 10. Any specifics, you know, this land goes to this child, or this investment goes to this child, you know, if you did things just not equally to everybody. So keep in mind, some clients that have had plans with us for a while might have some specifics for those things in Article 6 too. But Article 10 is where it's going to say if there's any other specifics of first right to rent, first right to purchase, and at what rates, is it on a contract for deed, things like that. Or is there any specific assets needing to go to specific people and not just equally to all beneficiaries? So as death trustees, this is another really important article to pay attention to, because this is what's going to guide us in distribution of where things go when you're both gone. And then Article 10 is where it's going to have, and some people it might not be Article 10, it might be Article 11. Some people might have some extra tax articles in between that have pushed it past Article 10. So it's going to say my descendants' trusts on it. So no, it might not be Article 10, but it's going to be after those tax articles. Also in this article about how things happen on death, this is where it's going to say whether or not mom and dad's assets are passing down into the protected trusts for their kids, their beneficiaries. Almost all of our clients have it passing down in these protected trusts to the kids on both death because it protects their inheritance from divorcing spouses, creditors, catastrophic illness. So in Article 10, or whatever article it is, it's going to govern, is it going in trust to these kids in these protected trusts? What access do they have to it? Usually it's full access, but some clients will put restrictions and things, so there might be some specifics there for the protected trust for the kids. And then it's going to say too, at the very last paragraph, it's going to say what happens if they pass away. Or most of you are going to have it going down to grandkids, to their kids, and so forth, to stay in the bloodlines. So that's the article that really helps us, what we're distributing, what happens if someone's already passed away and predeceased mom and dad, where are we going with it, things like that. So that's another one to pay attention to. The rest of the articles in the trust, those are all there in case we need them, have the rules for the trust. So obviously, as trustees, I recommend you kind of look through it, see what's in there. It's going to have your trustees' powers, here are all the powers you have, and things like that. But I'm not going to go through all that today. But they're not as important as these other articles, but you still want to go through them and know what's there. After the trust, you're going to have the pour over wills. So our clients, I know I've talked about how we don't like wills, they have to go through probate, they don't give you much protections beyond avoiding probate if you get your assets out of your individual name. But we have pour over wills for our clients that are going to say if any of their assets are not in their trust when they pass away, typically it's going to be the vehicles. This will says pour it over, use your power as the personal representative, which is typically going to be the same person who's the trustees on the trust, to get control of that and get that asset to the trust so then it can go down as the trust set. So that's their pour over wills. So trustees, children know that their wills aren't going to say, here's who's in charge, how our assets pass down. That's what the trust is going to do with all the specifics. The will is just saying, here's who's in charge of the assets that aren't in my trust on death, get them to the trust. So there'll be a list of personal representatives in there that you might want to look over. Again, typically it's going to match whoever was the list of people in control of the trust. Question?
Does the pour over protect it from probate?
Does the pour over protect it from probate? Well, it depends, right? Because whatever asset is in your individual name that we're using this pour over will to get it to the trust, what asset is it? What is the value of that asset? So if it's real estate of any value, and we're using the pour over will to get it to the trust, we're going to have to put that pour over will through probate to get it to the trust, or other assets over $75,000. We if we're not worrying about real estate, or it's a couple cars that aren't worth much, we don't have to go through probate. In the pour over wills, it's going to say if we have to go through probate, we want informal proceedings. So we want the quick version that costs less, the less involvement by the court. Question?
Is that $75,000 cumulative or per each individual thing?
No, the asset that was $75,000 together or per each asset. So that's $75,000 together. If it's over that together of all the assets in your individual name outside of real estate, that it would have to go through probate. Another question?
$75 per person?
Yeah, so on each death, yep. $75,000 on each death. Okay, next you're going to have a tab for the certificate of trusts. So right now they have the certificate of trust in there that are going to show that each other are trustees of their trusts and what they can do. And so these are these documents that are short versions of their trust that just have the information that these companies need to know. We don't want them to have these big old trusts with your private information in it. So the certificate of trust is what you use to make copies and give to the banks and places to show here are the trustees, here are the people that can do whatever they're asking you to do. So the ones that are in mom and dad's book are the ones that they did originally when they created their trust. So it's going to be them as trustees unless they had a child as a trustee right away. So keep in mind that those might have been updated. There might be in their book somewhere else white copies of certificate of trust that have a big blank white spot up top, because if they've changed trustees from the original ones, there might be new certificate of trust within there that would need to be used to show the current trustees. Okay, trust assets tab. So this is where we tell our clients that once they get that asset list from us, and the life plan clients, you are turning that into us yearly, and we can update that and get you new updated ones yearly. This is where I recommend that they put that. So trustees is under the trust assets tab. You're likely going to find that asset list of all of their assets. If it's not there, it might be within the book somewhere else. Because I tell clients you can put it here, or if you want it more accessible in the front or something, they can have it there too. So it may be there, it may be within the book somewhere else. And then we're going to have the healthcare documents. So with the healthcare documents, you're going to see the HIPAA first for dad, who has access to medical information. And so if you're a trustee, your name's likely here too, because you're a child, you're going to get access to the medical information. And then after the HIPAA is the healthcare directive, who can make the healthcare decisions for mom and dad if they can't make them. And then they're going to have a list of these healthcare agents who can make those decisions. Now keep in mind, this list might be different than the trustees, and we tell the clients, this list should be different if it needs to be, right? Because the trustees, the people on your power of attorney, they are the ones in charge of your finances and your assets and things with those decisions. So who's the most responsible and the best at that? The first one might be the third one on the healthcare directive, because maybe they're more emotional, or their other siblings are nurses and doctors, or married to nurses and doctors, and so then it's going to bump the other ones up, right? So keep in mind, we're always recommending our clients. So if you're first as a trustee and you're last on the healthcare directive, don't get offended. Where you can blame it on me. I'm typically telling them, hey, you do want to pay attention to who you have in charge. Make sure it's who you want, who's making the best decisions, and would be the best at it. In their healthcare directives, that's also where you're going to find if they want to be let go naturally, organ donation, final resting place, those kind of specific decisions that they've already put in there that they want to make sure that you follow. And you might see, so then we have memorial instructions. So we have that in there for our clients to fill out. It's not a legally binding document, but it's in there for them to fill out as a good gift for the spouse and the kids. So that might have some of their decisions on there for their services. Or if they have done the pre-funded funeral policy, there's probably a packet of information either there or somewhere else within their book or in their important documents at home with their pre-funded funeral policies. That's going to have all that done and laid out and all that paperwork and contracts and stuff. Next is that personal property memorandum I was talking about with any specifics. So each mom and dad, each trust maker is going to have a separate list where they can list out, I want this to go to this person, you know, and remember, you want to date and sign it each time you add things. So a big thing with these trust books and all these documents is we don't want anyone to write on them. We want to keep them nice and original, because copies are just as good as the originals. Now, the exceptions to writing on them are the memorial instructions and the personal property memorandum. Obviously, you can write in at those at any time you want to. You leave them in the book for your spouse and your kids to find. You don't have to get us a copy of those. When they bring the trust book in at that initial administration meeting, that's when we flip to it and look and see what we find of what they wrote in there. But remember, everything else, keep nice and clean. You make copies of it to give to people. You always want to keep your originals in there. And you can't just cross off any amendments, right? Or, cross out something and write something in that you want. Remember, you need to have it done in writing, signed and notarized by you to be a valid amendment. And then the last section is going to be for other documents. Some of you might have separate property agreements in there, and those were things that we did a long time ago that we're not doing now. So you might have some other tabs in there for clients that have been here for a while, but those aren't typically going to be as crucial of documents as what we're going through right now. So the last tab is going to be other documents, where we tell clients, here's where you can put any of your other documents that relate to your estate planning if you want it all in one book, right? We call this book your estate planning portfolio. We call it your trust book, but really it has more than your trust in it. It has all of your documents in there for mental incapacity and death. And so if you want any other documents in here, you can definitely put them back in the last section. So then that way it's all there for your spouse and your kids to find. Okay, at trust settlement, the trust makers are the client. So on death, and we're dealing with the trustees, then obviously we're representing the trustees as our clients for this estate. And so we are not representing each beneficiary in their individual interests, right? We're representing the trustees, we're representing the estate. So again, we can't talk to anyone besides the trustees unless the trustees give us consent to talk to anyone else. And clients who are in life plan, when they pass away, if they're in life plan that year, that first initial meeting with me, we already have it on contract, right, that it's going to be no additional charge. So administration work on death is charged hourly at $2.50 an hour, except for that first initial administration meeting with me. They're in life plan on each death. That meeting is going to be no additional charge. And then everything after that will be charged hourly, like creating the certificate of trust, getting the EIN, updating the asset list, things like that. And the successor trustees have no duty to hire our firm. So at the initial meeting, I'll be telling clients, okay, we recommend you hire us since we've done the planning, we're up to speed, but you don't have to. You have a legal right to hire whoever you want as an attorney to do the administration of this trust. So keep that in mind. You don't have to go to us, but I think I've heard a lot of my clients tell me, like, we're telling them where they have to go and they have to come back to you guys, the ones who have done our planning, because it makes sense, right? The downside is that they go to someone else who hasn't done any of this and they need to read through this whole book, and you're charged hourly to get up to speed to where we're already at. So, but you have that option to go elsewhere, because some trustees might do that if they don't live near Windom or us anymore, and mom and dad didn't either. There might be some situations where it might make sense to choose someone other than us. Okay, here are some cautions as a trustee. So you'll have them on your page here, and I'll just kind of rattle them off quickly. Never commingle trust funds with personal funds, especially when we're dealing with on each death and these trusts being irrevocable. We don't want, the trustees don't commingle any of your personal funds with the trust funds. And when you're inheriting in these protected trusts, you only want what you inherit from mom and dad in these protected trusts. All your other personal assets with spouse and stuff, you need to have a separate estate plan for. The minute you commingle your personal assets into your protected trust with the assets you've inherited from mom and dad, you lose those divorce creditor protections and things. Always use prudence and reasonable care. Seek professional assistance when you know your skills and experience are lacking. And I know where mine is. I specialize in estate planning and elder law, and I have general ideas of taxes and things like that, and I can say, okay, here we've got to worry about these certain tax things, but when it really gets deep into it and income tax rates and all these other things, I say we need to circle in your accountant, financial advisors, where they're the ones who specialize in that, and we want to get their expertise also involved and work as a team. You're responsible to the beneficiaries. Trustees must always act in the best interest of the beneficiaries and always communicate. You need to communicate with the beneficiaries, advisors, co-trustees, anyone involved with their assets, and respect deadlines for action. So leave yourself and the advisors enough time to meet deadlines. So one example of this is on death is if they're over the $3 million, they have to file an estate tax return, or if they're over the federal exemption too, right? But if they're over the $3 million in Minnesota, the trustees have to file an estate death tax return within 9 months of passing. So that means you want to get the appraisals going, because sometimes those could take a couple months. So you get those going, and if you think you're close, to this $3 million, then you want to be talking to an accountant and giving them a heads up and seeing what your accountant thinks. Because these estate tax returns are more complex and different, and not all of your CPAs will make you do estate tax returns. So always keep that in mind. You might have to go to a different accounting firm who will deal with the estate tax returns. So that's a big deadline on death. If you have to worry about it, of course, right, for estate taxes is getting that return done within 9 months and giving your accountant enough heads up to prepare it and getting them the information they need. Obviously, they can ask for extensions and things, but just keep in mind, because if you miss this deadline, you got crazy penalties and fees. So what are the next steps? So I would say, okay, we did this general idea and we pointed out to the trustees, hey, here's some specific spots you want to look in mom and dad's trust. But what you want to do is whenever you're over at mom and dad's house, and like for the holidays coming up, it's probably not something you want to talk about, but go over things with them. They can let them look through the trust book, make sure they know where the trust book is at. I have a lot of people who ask me, should we lock it up in a safe or put it in our safety deposit box? And typically my answer is usually no, because we want to make sure that your kids know where it's at and they can get into it, right? That if they don't have the key or the combination to get into it, then how are they going to get in, right? So if you want to put it in a safe, obviously make sure your kids know the combination and know where the keys are, have access to it. But you don't have to put it in a safe, because remember, copies are just as good as the originals. When you did your plannings with us, we made sure we scanned in a copy to have a copy in our system as a backup in case you lose it, it gets destroyed, right? So you don't have to, put it in a safe. The issue with safety deposit boxes is making sure that your kids have access to that safety deposit box. And another thing that I think might be a hassle is when you're alive and well and you keep it in your safety deposit box, you got to go to the bank every time you want to look at it or something. So it is okay just to keep it in a safe place in your house that you know where it's at and that your kids or your trustees know where to find it. All right, so in closing, being selected to serve as a trustee is an important service you can do for your loved ones. Your job involves much responsibility and accountability, and I realize everything we've just went over is, probably a lot, and you're like, oh my goodness, can we do this? You can, and we're here to help you, right? So you're able to call us in those administration meetings too. We're sitting down with you. Those meetings are a couple hours at a time to go through the to-dos and things, and we're here to help you every step of the way through that and walk you through this overwhelming book. All right. So in closing, we could take any other questions if you have them, and then remember to hand in whatever's easiest for you. You can leave those client suggestion forms at the table, or you can hand them off to Abby at the table there as you walk out, whichever you prefer. So we recommend you fill those out, or you can always mail them to us later too. Our address is down there on the back page. Also, another reminder that if you haven't grabbed your annual client meeting packet, grab that on your way out, and Abby will have it. Okay, it was doing this to me when I looked at the PowerPoint last night and I retyped it in. So those dashes there is supposed to be our address, which luckily you should have it blasted all over your documents in your trust book, your trust ID cards. But that was supposed to be, and I don't know, did you guys get it printed out at least? Good. So it printed out with our address on there. So it's the 332 10th Street in Windom, on the square there next to the Hallmark and Shannon Lynn's Boutique. And then we have the phone and fax number, which hasn't changed since Shannon took over. And then this blue line down here is supposed to be our website, www.fordlusfieldlaw.com. Again, it's not up and rolling. Apparently it takes like several days to redirect domains and stuff that I didn't realize. So it's in the process, and hopefully next week it should be where it needs to be. But again, it's going to be up and running by the time you need to go there to find the links for the YouTube to watch these videos again for those who weren't able to make it. So you'll be able to find a YouTube link there on our website as well. I also have it on here. So we're also trying to ramp up our Facebook presence and things, and trying to keep our clients updated with all of our happenings and workshops and things on there. So if you haven't already, go and like us on Facebook, Ford and Lusfield Law Office, LLC. We also have Instagram. I know most people probably don't have that, but we have that, and it's easy if we post to that. It posts to Facebook right away too. So we have both. And then we have our YouTube link again there for you, where you can go back and find these links to watch these videos of these meetings within 30 days after each of the meetings. They'll be uploaded. And then I also have our emails. I have Abby's email, and Abby is back there. She's the client service coordinator, office manager. She does all the things to help keep me and the office intact. So she's the one that, her email is probably the one that you might use most often to get responses quicker than from me. And she's able to help you with a lot of things that she can help you with and don't necessarily have to wait for me to help with. So Abby's email, and then we have Allison Tordick is our funding coordinator and administrative coordinator. So especially on death, first death, second death, Allison is the one who is helping me with these to-dos. Abby's also helping with like the certificate of trust and stuff, but Allison is helping us update the asset list, get assets transferred to the family trust, or getting them transferred to the kids. So her email is helpful. If you need to email her for any funding questions or update any of your funding and your assets and stuff, you can email her directly. If you're in the administration process and you're updating data death values, then you can just email those to her directly, because she'll just update them in the asset list. And then we have my email as well. And I'm going to try to remember to get back there and show Abby some business cards, so then that way somebody can grab that if you want it. But I don't have a bunch with me today. Okay, that's it. Any other final questions? One right here.
Okay, this is a big book, and a lot of times the kids don't have time to go through them. Can they get it like on a flash drive or email?
Yep, so she asked that you have the big book. Sometimes the kids don't have time to go through it. Can they get it on a flash drive or email? And so I'd say you can do that, but you have to make sure, because when you're alive and well, if you give them one copy, if you have changed it, made amendments, or like your power of attorneys, your healthcare directives, when you make changes to those, we give you completely new ones. So if you're going to do that, you need to make sure that each time you change a document, you're giving them that new document on the flash drive or email. So then they're up to
Flash drive
speed.
back to you, then you could make the updates in your office, then they can send the flash drive back to the
Trustees. Yeah, so you can provide us with a flash drive. We can upload your documents on it. We'll make sure we can upload your most recent documents and any amendments, and then we can get that to your trustees. But yes, again, keep in mind, you want to let us know if when you make changes again, you have to tell us, hey, you want to get this sent, or you be in charge of sending it to your kids to make sure they're updated. So what they're working with and seeing, making sure it's not an invalid document. Question?
Where would you suggest we put our amendments in our portfolio?
Where do you put the amendments in the book? So we say that for the trust, so when you make amendments to the trust, we're not just removing and replacing the whole thing like the healthcare directive or the power of attorney. You're making amendments to it, and you want to put the amendments at the front top of your trust. And as you keep making amendments, you have the most recent on the top. So ideally what you want is dad's amendments, then you have the first page to dad's trust, then you go to mom's trust, mom's amendments, first page to her trust. Because remember, trustees and myself, when I'm going through it, we always want to know, we want to see these amendments first before their original trust, because we want to see what is the valid and most effective provisions that we need to be paying attention to, because in the original document, we leave the original there, and we're saying, hey, maybe we're removing and replacing Article 3 completely and giving a new one in an amendment. And we got to pay attention to that, because it's probably changed trustees. So that's a good question. It should always be in front of the trust. If it's not, that's okay. So as trustees, if there's no amendments in the front, you might want to just page through everything to make sure there's no amendments elsewhere. You can also talk to our office, because we should hopefully have scanned-in copies of their amendments that we can let you know of, or reprint of things. Was there another hand? I thought there was another hand. Anyone else? Okay, so, question?
Relax your hand and have them check off all these things. You had a piece of paper, you're supposed to do all these changes. You don't have anything like that this year?
So she said that in the past years you've had all these checklists of things that you're supposed to check off to do, and asked if we had it this year. So at the trustees training, we don't have checklists like that. It's the annual client meeting where you're gonna get those, here's what you guys need to do, the client to-do list, and if there's any amendments to check off that you want. Yeah, so those would be at the annual client meeting, which you'll find that information in your packet, your annual client meeting packet, if you haven't gotten that already. Okay, I don't think there's any other questions, so that is it. And again, feel free to call, do in-person meetings. And I think there's plenty of donuts back there. Please take some on the way out, take for grandkids, whatever. Help yourselves. Thank you, and enjoy the rest of your weekend.